DUI shatters lies, myth versus reality. Understanding the criminal justice system. Who is who, what they do, and why it matters. One question at a time. What does the defense attorney really do? Well, the defense attorney represents the defendant, not the victim. One of the biggest myths television teaches us is that a defense attorney represents someone because the attorney believes that the person is innocent and proves it. The reality? The defendant does not have to be innocent for the defense attorney to fight for them. The evidence may appear overwhelming. The defendant may have confessed. The defendant may even decide to plead guilty. In my son's case, Dennis was found still seat-belted inside his overturned car after the crash. He was too intoxicated to complete a breath test, and a warrant was needed to obtain his blood for BAC testing. Yet, he was not arrested until 9 months later. Once the blood test was completed, I remember thinking as a victim, this makes no sense. If someone is too intoxicated to complete a breath test, why do we still need a BAC number to prove intoxication? What I had forgotten was that the defense can challenge almost every part of the evidence. Kelly's dad had served as an expert witness for the state in other cases, and he often talked about how defense attorneys would challenge his testimony, question his conclusions. The purpose was not necessarily to prove that nothing happened. It was to create doubt about the state's evidence. That is something victims needed to understand. Evidence that looks obvious to us may still be challenged piece by piece in court. Always remember, even when the evidence may seem overwhelming to the victim, the offender still has constitutional rights, a defense attorney protecting those rights, and a defense team looking for every legal way to challenge the evidence, reduce the charges, negotiate a plea deal, or lessen the punishment. In other words, a get-out-of-jail-free card. So do not make the mistake of thinking the evidence proves what happened, so there is nothing for the defense attorney to fight. That is their job. Even when the person they represent is guilty, to a grieving victim, it can feel as though the person you lost and the life they lived is the one being placed on trial. Hello, I'm Sarah, Kenley's mom. Many of you know me as Mama Bear. This was one of the hardest truths I learned as a victim. Offenders have attorneys guiding them and protecting their rights from arrest through sentencing, appeals, and often parole or release. Victims must fight to discover ours while grieving, traumatized, and trying to survive. I feel it is unfair, but it is reality. When my son Kenley was killed, I had to learn about the criminal justice system while I was grieving, frightened, and trying to understand what was happening. I'm not an attorney. I'm a victim and a mother sharing what I learned so other victims may know what questions to ask, what to do next. Before my son was killed, I thought the criminal justice system was simple. If you drove drunk, killed someone, and the evidence proved it, you went to jail. I thought the evidence would speak for itself and there would be nothing left to argue about. Boy, was I wrong. The defense does not simply accept the evidence because it appears obvious to the victim. Their job is to challenge piece by piece, looking for anything that could create reasonable doubt, reduce the charges, lead to a plea agreement, or lessen the punishment. That was one of the hardest realities I had to learn after becoming a victim. A defense attorney can challenge blood or breath testing, question police procedures, attack the reliability of witnesses, dispute how evidence was collected, and hire experts who offer a different interpretation of what happened. Defense attorneys can be very creative, sometimes so creative that as a victim you may wonder if you accidentally walked into a courtroom or a cartoon. Over the years, I have covered some unbelievable defense strategies. The so-called Twinkie defense, affluenza defense, alien defense, Bigfoot defense, and my personal favorite, the Bugs Bunny defense. Yes, you heard me right. And those are only a few. Some of these arguments can sound absolutely absurd, but the defense is looking for anything that may create doubt, shift responsibility, reduce the charges, or get a better outcome for their client. So never assume the evidence is obvious. What could they possibly argue? Trust me, they may find something. That is why Mama Bear says, know the evidence, know your rights, and never assume the courtroom will be as simple as common sense. That is why victims need to understand this before they walk into the courtroom. The defense attorney is not there to find justice for the victim. They are there to create doubt. The defense attorney is there to provide the strongest legal defense possible for the defendant. Even when the defendant has admitted guilt or the evidence appears overwhelming, they only need to create reasonable doubt. Now, a warning for victims and families. The defense attorney may look closely at you and your family, your statements and your actions. Anything that can be used to question your credibility, challenge your version of the events, or help the defense may become important. That is why victims and families need to be careful about what they say and do while a criminal case is pending. Something as simple as Facebook posts can potentially affect a case. Be careful about what you post on social media, what you say publicly about the case, questions you answer from people you do not know, conversations you allow someone to record, messages, emails, photographs, or videos you share. You may believe you are simply telling your story. The defense may look at the same words very differently. This does not mean victims should be afraid to speak. It means you should understand that once a criminal case begins, words and actions can sometimes become evidence or be used to challenge a witness. Think before you post, think before you answer, and know who you are talking to. In a future video, I will cover social media, recorded conversations, questions from investigators and attorneys, and other things victims should watch for. That is why you must become your own Mama Bear. My mission is to help victims understand and navigate the criminal justice system while they are living through trauma by sharing my personal experiences and the lesson I learned, and I am still learning. Having rights, knowing how to use those rights are two very different things. As a victim, you may be the person whose child was killed, whose family was destroyed, and whose life will never be the same. Yet you're still not the person controlling the criminal case. You do not decide what charges are offered. You do not control whether there is a plea agreement. And you do not have a defense attorney standing beside you whose only job is to fight for you. That is why you must become your own Mama Bear. And why I want every victim to learn these lessons before they must learn them the hard way. This is lesson 3 of series 2, Understanding the Criminal Justice System. Join me for lesson 4. What does a judge really do? Thank you.